Hello and welcome to our show, Dying to Know. My name is George Horattas and I'm with Resurrection Cemetery. The goal of our program is to bring you topics and guests that will help you make life's important decisions, that will help you prepare for the future and protect your loved ones. Very excited to have our guest today. We have Mark Strek from Heiritage Law. I'm so glad to have you on the show. There's always questions and confusion regarding estate planning, and I'm sure you of all people know that and have to try and make it simple for us and guide us to get the right plan.
Absolutely.
So,
my pleasure being here.
Yeah, and so tell us a little bit about how long you've been doing this and a little bit about your firm.
Okay, so I have been practicing solely estate planning going on 14 years now. Heiritage Law, we started about 4 years ago, and that is all we do is estate planning, wills, trusts, power of attorney, patient advocate. Our goal is to keep families out of court. We're also really big on educating the communities. So you've been to our office. We have the in-house seminar room. I consider my job, I've done my job even if I don't get a client, I've educated a family, because it isn't always necessary that a trust or a will or this or that be set up to avoid probate court. So it really depends on the individual family and situation.
So tell me about how does it start? Someone will call you or someone might come to your seminar. What is the first, how do you start?
Yeah.
How do you know what people need?
So typically the first appointment, we kind of just gather information on the family situation, because there is no, let's say, normal family anymore, right? And every family may have certain dynamics where they have good kids, bad kids, no kids. Those are sometimes some of the hardest ones, is when they have no children, right? Trying to figure out who they trust to handle this stuff. But we'll go through that fact finder, go through assets also. It's one of those things we need to know about it to protect it. And sometimes clients are kind of adamant about going through their assets, but again, it's one of those things we have to know it to be able to protect it. But some attorneys also do, run through those assets and determine their fees. We don't operate that way. We've got a set fee schedule. I'll put the paper right in front of you, show you exactly what the fees are. And then once we get that initial appointment down, we set up a follow-up. Normally that second appointment, we've got everything ready, drafted, ready to sign the documents, and they're all set.
So does everyone need a plan?
No. So there are certain things that I say everybody over 18 should have. Now there's two types of probate court, and I don't know if the viewers all know what probate court is. Myself personally, when I started law school, I thought a tort was a dessert, and probate had to do with criminals. So probate court, there's two types. There's while you're alive, that's your guardianships and conservatorships, and then after you're gone, your decedent's estates, that's for assets that were just in your name only and didn't have a beneficiary or a joint owner. The only way to get those from the decedent to the beneficiaries is through probate court if you have no documents set up ahead of time.
So is it true that if you just have a will, it will go through probate?
Yeah, so the will just tells the judge in probate court who to put in charge of your estate and how to distribute the assets. It doesn't keep you out of probate court, which is a big misconception.
So it almost sounds, if you have assets, that you should have a estate.
Yeah, some sort of plan. Again, I've got my wise guys who say, "What do I care? I'm gone," right? So
I hear that too.
Right, exactly. With what you do, right?
I don't care.
Yeah. So they don't realize if you don't have anything set up, such as a power of attorney or a patient advocate, those things affect you while you're alive. If you have no legal documents in place, anybody could petition the court to be your guardian if you couldn't make your own medical decisions, or your conservator if you couldn't make your own financial decisions. And again, now we have courts and judges making these decisions as opposed to you setting it up, you picking the people you trust. And nothing against the judges here in Macomb County, they're great, but a spouse is gonna know better than a judge what that spouse would have wanted, right? Because that's another big thing is we're married, what do we need this stuff for?
And then I imagine going through probate probably takes a long time, doesn't it?
It does. For the
before it's settled.
decedent's estates, normally I tell clients, by law, there's statutes that say it has to be open a certain amount of time. But realistically, the process is going to take up to a year. Minimum, I'd say 5 months.
Now, let's say someone only has a home. Let's say they don't really have money or assets and their bank account is already in a kid's name. What if they just have a home?
So if they just have the house, that's actually one of the most commonly probated assets we come across, because people will put beneficiaries on their bank accounts, right? Son, daughter, brother, sister, whoever. But the house is still the same way it is the day they bought it. It's deeded to so-and-so, and that's it. So if they pass away and they're the only one on the deed, the only way to get it out of their name is through probate court. Again, we can avoid all this with pre-planning. Simple quit claim deed could have avoided a multiple $1,000 probate after you're gone. So, and there's different types of ways that can be set up. I will have, families that come in too that they deeded the house to or added their kid to the deed. That avoids probate court, but there's a lot of these things where people try to do, self-diagnosis almost of their estate, that they don't realize they're opening up their assets while they're alive to those liabilities. So what I mean by that, Georgia, is good things or bad things happen to good people all the time, right? So with these new insurance regulations, or basically any liabilities, if you put your kid on the house and record that deed and they get sued, divorced, bankrupt, any of these things, now your house is subject to those liabilities. Same with a bank account. We'll have
doesn't a trust avoid things like that?
Yeah,
you're protected from.
Exactly. So that's one of the benefits of a trust, is it's going to isolate that so that you can basically avoid probate court and avoid liability for beneficiaries.
So years ago, I know my sister, when she bought her home, she's single. I have a quit claim deed for her house.
Okay. Are you a joint owner?
No.
Okay, so it says it's her house as long as she's alive.
Right.
When she passes, it will automatically
That's when I
transfer
run to the county
That's
or
the
something.
ladybird deed, right?
So it's kind of like
There's
that.
a couple different, So
Okay. So she was probably smart to do that.
Right.
Okay.
Unless it's not a ladybird deed and it's just a regular deed saying it goes from, it's her house and she's deeding it to you, and George, go record this after I die. Because that's another, it's not recorded, it's not public record, but you guys have a falling out, you grab that deed, you go and record it, now you own her house and she's still alive.
I'm nice to her with that in place.
That's good. Not all families are nice to each other anymore, believe it or not. That's one thing I've seen.
Well, you just said at the beginning of the program, there's all different kinds of family anymore. And that is true.
Yeah.
So I remember when we did our trust way back in the beginning, the questions we were asked, it was all I could do to stay awake. I was yawning. I was so mentally fatigued. And
sorry you had to go through that. We try to handle things. We try to make it a little bit more fun.
Because you make us think.
Yeah. Yeah.
What do you really want and who do you want involved?
Right.
And when you have to start thinking of that, like, oh, do I?
And I'll have a lot of clients that come in and just like you, they don't really know or we don't want to think about these things, right?
No.
It's not fun to think
Same
about,
as the cemetery.
Yeah.
People come in and don't want to face their own mortality,
if there's a secret out there to avoid death, tell us about it, right? You'd like to know as well, George, I'm sure, but there isn't. That's one of those things, death and taxes, right? Guaranteed.
So I found that also updating your trust, how often should people do that? I know that sometimes you have a representative that might pass before you, or things change, or there's a falling out. How often should you update?
So really, unless there's a law change, if it's set up correctly the first time, I'm going to run through worst case scenario, right? When we're in that appointment, I'm going to say, okay, you want it to go to A, B, and C, John, Sue, and Jill. If Jill passes away, what do you want to happen to her share? And we're going to run through that worst case scenario so that if something happens to one of your beneficiaries, we've already covered that. You don't have to update it, because that's, I have to be careful here with the way other attorneys may operate, right? I'm not saying anybody's doing it the wrong way, but unless there's law changes that affect your plan, it could be set up initially where it could be set it and forget it. Now, again, it's going to depend on the client too, though. If I have a younger family, like, I have little kids, I might want to put them in charge instead of, my brother after I'm gone, right? Once they're over 18. And if they're in their mid 30s, maybe I want to just change the roles of who's doing what. But a lot of my retired clients, unless there's a law change that affects their plan, we could essentially set it and forget it.
Do you necessarily...
Which I'm sure you're probably surprised by that, because a lot of other attorneys say, oh, it's this growing thing, you need to update it, you need to update it.
And you're not really starting from scratch. There's updates.
Right. So the way I handle things is if there's a law change that affects your plan, I'd get in contact with you. Hey, this law changed, it affects your plan. We need to add this article or amend your trust. And again, depending on the attorney you see, that could be handled, different ways.
So
I can just tell you how I do things.
Yeah. So if I have beneficiaries designated on my whatever, and can my will override that?
That's a good question. Actually, I believe it or not was at a local bank this morning talking to them about this, because is kind of guiding them, because their worst part of their job, they told me, is when a family member will come in after somebody passes and they have to tell them, sorry, we can't give you any information on the account, right? If there's a beneficiary listed, that's going to trump your will or trust. So that's a way where if I have somebody that's kind of, because I have clients too that I do not want to trust, no matter what, I don't want to trust. I've heard bad things about trust. It's all probably false, what they've heard, depending on where they got their information.
It makes sense you should have one.
Right. Yeah. Right. But there are ways it can be set up and avoid probate court. If we all knew how life was going to go and it went as planned, we don't need a trust, right? You got two beneficiaries, you make them the beneficiary of all your accounts and do the quit claim deed, and life goes as planned, and they don't have to go through probate court because they survived you. What it doesn't account for in that plan, though, with no trust, is one of your beneficiaries predeceases you. Now what? If that happens, is your first thought going to be, oh, I need to run to the bank and update my beneficiaries? Probably not. Or if any of those beneficiaries were going through bankruptcy, divorce, lawsuit, creditor issues, all these things we could run through, again, liabilities.
Didn't think of that.
At the time you pass, now think about it, they're in the middle of a divorce or a lawsuit, and now they inherit all this money.
Wow. Mm-hmm.
They're going to come after that. Where the trust, that would be protected. It can be held in the trust under the spendthrift provision.
Speaking of, you're having a trust and there's minors as far as beneficiaries, what is your advice as far as a proper age?
Yeah.
And who do you use? Do you involve a parent in the distribution of this? Tell me how that works, because we had a few minors and it was recommended a certain way.
Yeah.
So.
And it's not even always minors. Maybe your beneficiary is over 18, but
you don't want an 18-year-old to have.
No.
Yeah.
If I were to have inherited money when I was 18, I would have blown it personally, right?
For sure.
And I was a pretty responsible 18-year-old, but still, it's when you get money that you didn't earn, it's easy come, easy go, So with the trust, and that brings me to another point. Sorry to digress, but there are a couple situations where I say a trust is kind of a must-have in my opinion, right? Minor children,
for sure,
you have to have a trust.
Yes.
For that very reason, right? We don't want the kids to get it at 18 to do whatever they want with it. In the trust, you can put until, like mine personally says, until my kids are 25, they could only access it for health, education, maintenance, and support. So important things, right? They can't get it at 16 to go buy a new Corvette. They can't get it at 18 to go buy, spend it frivolously, I should say. But minor children and business owners, that's another big one where I say a trust is highly recommended if you have an LLC or a business interest, because those business bank accounts, it's one of those things where you can't put a beneficiary on it, right? So if you own a business, the only way, basically what we do is we assign that business interest to the trust so your successor trustee can still access those accounts and either sell or wrap up the business without having to go through probate court.
There's a term regarding trust that I've really never understood, and I don't think I'm alone in this. Revocable, irrevocable.
I see where you're going. Yep. It's another common question we get. What's the difference between a revocable and irrevocable trust? Biggest difference is, one, why we're setting it up. revocable living trust, your standard run-of-the-mill trust, that's primarily to avoid probate court. So when you pass away, everything goes smoothly. Your beneficiaries don't have to deal with courts or judges, and the distributions go out to the beneficiaries with those, kind of extra protections. If the spendthrift provision, if they have liabilities or if they're minor children. I guess the easiest way to say what the difference is your irrevocable trusts, those are going to be, they have a lot more protections for Medicaid, long-term care planning, as far as nursing homes go, which are expensive, as you know. But revocable trust, the grantor, we got George's trust. It's under George's social security number as far as the assets go, and George is the trustee. So George, you can do whatever you want, right? You're the boss, you're in charge. You can mess with the assets, take them out, put assets in. With the irrevocable trust, it's not under your social security number, at least the ones we use, right, for Medicaid protections. It has its own EIN number, so it's going to file its own tax return if it has income or gains, and you can't be the trustee of it, George. George, you have to appoint your sister to be the trustee.
Okay.
So
okay.
Part of the reason why they protect the assets, one, it's not under your social security number anymore. Two, it's got its, you're not the trustee, so you can't access those funds directly. Only your trustee can. But
so another thing I remember doing ours was you get this trust, and then you have to fund it. And I was thinking,
yeah, I
what does
can't
that
tell you how
mean?
many trusts I've come across that
that's
are
where the
not
work
funded.
comes in.
Exactly. Exactly.
Because if you don't follow through on funding the trust,
Worthless.
what good is it?
It's a paperweight.
I want you to,
And that's big on, again, where you get this set up. Just like all the documents we're talking about, I can say in general, power of attorney is going to keep you out of probate court as far as conservatorship. Patient advocate's going to keep you out of probate court as far as guardianship. A trust will keep you out of probate court. Again, those are all kind of in general statements depending on who assisted you with this. If you get it off LegalZoom or ask the robot, the chat GPT, to draft you up a trust, nobody's going over the funding. Even I'll have attorneys that'll set up trusts and they get done signing, here you go, you're all set. So the assets have to actually make it in there. And it's not a hard process, but that's the work that the attorney can't do for you.
right, because I remember I had to go to the bank.
Right. And that's another thing we talked about at my bank meeting today was they said, Mark, what's the best way for us when somebody comes into our bank and says, I got this trust. I wasn't really explained what I do with it, but they said I need to tell you at the bank. So it could be set up one of two different ways with the same result. It could be a brand new account made under the trust.
Under the trust name.
Yeah. Or you could just make the trust the beneficiary. We decided at the bank today, as I've always advised clients, the easiest way to do it is just make the trust the beneficiary of the account. That way we know it'll never go through probate court because that beneficiary isn't a human, right? It's a trust. It can't predecease you. We've got no issues there.
That's what we did.
And then also, it's easier for the bank to set up too. Because that was my big question. I want to make this convenient for the bank. I want to make everybody's job easier, right? And accomplish the goals.
So let's run down a list of things that you do to fund a trust. So we know bank accounts.
If you have an attorney set it up, before you leave there and you get your documents, it should be funded with all your personal property because you're going to sign a general assignment of all personal property to the trust. So the contents of the house, jewelry, collectibles, things like that. And then they should have a draft of a quitclaim deed or some type of deed putting the property in the trust also. So when you leave the lawyer's office, you should at least have it funded with the house and the contents of the house. What the lawyers can't do is the bank accounts, the life insurance policies,
Life insurance. Okay.
the annuities, the 529s, the savings bonds,
IRAs, and things like that. Okay.
And IRAs, that's a tricky one too, because if you're married, the IRA, you don't want the trust as the beneficiary, the primary beneficiary.
The primary should be the spouse.
Should be the spouse for tax purposes. So there's a new law that came out in 2019, 2020 called the Secure Act, and that changed the way those IRAs and 401ks are inherited. But you always want the spouse as primary. The trust is the contingent beneficiary on the IRAs. Any other joint assets make the trust the beneficiary.
Right.
If they're not a joint asset, spouse primary.
Boy,
It's a lot.
we're learning a lot.
Yeah.
Boy, it's so important.
And
It's
then
just,
those business interests too. That's another thing that is, I had it last week, issue where a business wasn't properly assigned to the trust, and now they have to go, and mom's incapacitated now, so she can't do anything as far as that goes. So they have to go to probate court, get a conservatorship to be able to transfer a business interest because it was never put in the trust correctly. And that's just kind of the tip of the iceberg, and everybody's different, right? Again, so when I set things up, I'm part of my fees, let's say it's a flat fee, that includes guiding you on funding the trust. We're going to go through every asset. We're going to check up and make sure that it's actually funded.
you're almost giving a homework to do.
Absolutely.
Giving them what their homework is.
Yeah, the first page in the binder when you get it back is your instructions. And I describe it just like that, homework. This is your homework when you get this back that I can't do for you. I wish I could, but it's not my account, so they won't listen to me,
Yeah. So once the trust has to go into effect, and if there's disharmony,
which happens.
how is that resolved? How?
So the trust does, a lot of trusts have provisions in there regarding that. If somebody contests the trust, no contest provision, basically, those aren't always upheld in probate court. But, it's, if we don't solve it on our own, we're going to go to probate court still, even if you have a trust. That's the reality of things.
But it's a lot cleaner.
It's a lot cleaner, and there's a lot of opportunity to resolve it before it gets to that point.
Right.
And, if we have a valid trust, and because we run into these situations all the time nowadays too, where one of the kids drags mom or dad to, not my office, but let's say another attorney, and they have mom sign a bunch of stuff when she's really doesn't have capacity, know what she's doing possibly. And it's not even attorneys. It's, all they need is a notary, really.
When you have that black sheep in the family,
Yeah.
and you want to make provision that they are not to.
So the old school attorney would say, leave them $1, right?
Yeah.
That would work. I mean, that way they can't, the problem is they could say, if you don't include them at all and don't mention them, is they can make an argument in probate court that you wanted them to get an equal share. You just forgot about them when you were doing this.
But can't you put that?
Yeah, so rather than leave them $1, I just intentionally omit them, make it clear as day they are intentionally omitted, because if you leave them $1, now they became a beneficiary of the trust. Now they're entitled to a full copy of the trust, a full accounting of the trust. Even though they're getting $1, they can still see the full accounting of all the assets in the trust. And they're, that's the beneficiary that's going to cause all kinds of problems because they're only getting $1.
Well,
so
every family has one.
Yeah. Yeah.
Not two. But,
Yeah.
there is always one. Do you pay taxes on what you inherit?
So in Michigan, there is not a Michigan estate tax. There is still a federal estate tax. Generally, that doesn't really come into play with too many of our clients because it's way up there, and $30 million plus for a married couple. I think it's 14 or 15 for an individual now. But there is, the way Michigan does it is there's no estate tax per se in Michigan, but there is an inventory fee. So if you go through probate court, the probate court charges basically this inventory fee that's based off of the value of the estate. And that's what I call Michigan's estate tax, is the inventory fee in probate court. And it's one of those sliding scales where basically the more money that goes through probate court, the higher that inventory fee is. So there's ways to avoid it easily though, right? With either beneficiary designations or trust.
What is your advice on picking your power of attorney in case you can't, and patient advocate? It's called patient advocate. Wasn't it called medical?
It's got 20 different names for the same document. Medical power of attorney, patient advocate, advance directive, living will. I've heard all kinds of names.
Yeah, so you should have a power of attorney in case, and then someone who can make medical decisions.
Right.
Right? Is this part of all this when you get this probably?
That's kind of the first thing we run through when you come in. I was telling you the initial appointment. That's the thing that everybody over 18 should have, is that patient advocate, or the 20 other different names. Basically, if you can't make your own medical decisions, it appoints somebody to be able to talk to doctors. as far as your desires and preferences for treatment, that would be right in there. So you're not leaving this on somebody else to make that hard decision. And most clients want the same thing. Typically, if you're choking on a chicken bone, try the Heimlich, right? Pill, surgery, treatment, procedure, going to make me all better, do it. If I'm in a permanent vegetative state, irreversible coma, don't keep me around forever. That's all in that document though. So if you appoint whoever as your patient advocate, they're not having to make that tough decision. They know what your preferences are. They just have authority to sign off on.
And I imagine there should be a primary, secondary.
Absolutely, yeah.
On these people,
the way we set things up, plan for the worst, hope for the best. So I want backups for everything. And that's where your smaller families, it's not on my part as far as drafting the documents, but it's when we're in that appointment, getting the gears turning in their brain of who they could trust to make these decisions for them or be involved.
I am all for pre-planning. I got into the cemetery as a profession when my mother died at only 60, and we had nothing done. I was looking for a new career, and it was one of the worst experiences.
Yeah.
And I learned a valuable lesson since then. And I'm a firm believer in pre-planning, regardless of what it is.
Absolutely.
Because coming in at a time of death in an emergency state is horrible. And I imagine you get phone calls from families who don't have anything done, and it's an emergency, and you've got to figure out all this dynamics to best guide them.
Yeah.
When all that can be avoided
easily
by just having a plan.
Correct. Yeah. And it's one of those things I'll have people also that think I don't have enough money or I don't have an estate, right? I don't need a plan. That's not the case. Like I said, those things that affect you while you're alive, everybody should have regardless of assets. And there are ways where you could make it affordable, and I'll give you your pros and cons of if you don't do a trust, if you don't need a trust, you just got to stay on top of your beneficiary designation. So at least at our office, we're trying to make it accessible to everybody. So we'll work with you. I'd rather help somebody than not.
I've always had the belief of, when you leave my office and you come into pre-plan, you're not leaving with anything tangible that you can go home and enjoy. What you have to leave my office with is
peace of mind.
Peace of mind.
Yeah, absolutely.
Because if you overspent and you don't leave feeling, you feel uneasy about how much you've spent, or you're not sure if you made the right plan, I'm not doing my job right.
Right.
So
I agree.
My goal is that you leave feeling peace of mind that a weight's been lifted, which is the same.
Absolutely.
When people come.
That's the rewarding part of my job is I'll have people that'll come in nervous, scared, don't want to talk about these things. And when they leave my office, they're praising me, thanking me, saying how happy they are, how much better they feel, how they have that peace of mind, how they can now, believe it or not, this keeps people up if they don't have it set up sometimes.
I always say, and I train new people at work, I say, if you know the courage it takes to touch our door handle.
Exactly.
You've either had a death and there's an emergency, or you saw something outside, you're emotional, you want to be heard. Absolutely. You might have a complaint.
Yeah.
You're coming into pre-planned, so you're facing your own mortality. You might have just been diagnosed.
Right.
So to touch our door handle as well as yours, fear of the unexpected, not knowing what to expect, is hard.
Yeah.
So if people treat, people who come to their establishment like that,
absolutely,
the goal is
you have to have empathy
mind.
With what we do.
Yeah. Very
really,
much
and
so.
you have to be doing this for the right reasons.
Yeah.
Both hand in hand, both of what.
Well, I'm glad we have you in our corner.
Yeah.
And
absolutely. Thank you.
I urge our guests to take that first step and make the phone call. And, you have a exceptional reputation in the senior community.
Follow the golden rule, George.
And, that's why I trust you and why I wanted you on this program. And I can't thank you enough for everything you taught us today.
Absolutely.
Appreciate it.
My pleasure. Anytime.
Thank you.
Thank you.
This concludes our show for today. As usual, we'll bring you topics and guests that will help you make life's important decisions, that will prepare you for the future, and help you protect your loved ones. Thank you, viewers, for tuning into this episode of Dying to Know.